I think my favorite Nicholas Sparks book and film has to be Safe Haven. It is very well acted, set in a beautiful seashore community in North Carolina, but it's more than just a romantic tale. It's an intriguing, nail-biting drama, a good read and a good view. But the underpinning of the story, the theme of the story, is a very serious subject: spousal abuse. And that's what our episode tonight is going to be about. Now, we all know that spousal abuse is bad, but what does the law say? What do the courts say? What do judges say? What does the public say? You may be surprised at the answers. We have an expert with us, fortunately, Barry Goldstein, who is an expert on spousal abuse as well as an attorney. And our host is our own Jennifer Yoon, also an attorney. So let's give a listen and take a look and see what we can find out. I'm Bob Ward, and this is Above the Bar.
Today we have a very special show for you. We have the author of Domestic Violence, Abuse, and Child Custody, Mr. Barry Goldstein. Mr. Goldstein, welcome.
I'm really pleased to be here.
It's a pleasure to have you here. Before we get started, I just want to highlight a few things that you and I had spoken about earlier. I'm sure many of your viewers, or some of them, have personally dealt with domestic violence and child custody issues. But for others, like myself, we probably just heard about it vaguely in the news. You'd given me some alarming statistics that I wanted to kind of cover. You'd told me that over 58,000 children a year are being sent to live with an abusive parent. That's over 1,000 children a week, correct?
Yes.
Yes, and the more alarming statistic to me was that over 100 children a year are actually being murdered by an abusive parent. And to me, I believe this is a direct relation from the child custody courts that are sending these children to live with abusive parents. So can you tell us why this is happening?
And I want to say it's really abusive fathers. One of the fundamental problems we have is that the court system has been taught that contested custody cases are high conflict cases, by which they mean the two parents are acting out against each other and using the children. But the reality is that 90% of contested custody cases are really domestic violence cases. And what we see over and over again is that fathers who had very little involvement with the children during the relationship suddenly go after custody as a way to pressure the mother to return or punish her for leaving. And the courts are not recognizing that, and they're busy trying to make the protective mother cooperate with her abuser, and the results are really tragic.
And when you say high conflict, what does that mean in legal standards?
To judges who don't understand this case, what that means is that both parties are acting out, that they're angry with each other, and so they're taking it out on the children. That's what they think is happening. And again, in reality, it's mothers are trying to protect their children from fathers who have abused the mother and often the children. And when she tries to protect them, the court is treating her as if she's interfering with the relationship with the father rather than doing what she should to protect her children.
Can you tell us a little bit more background about how this whole misconception about high conflict and domestic violence actually made its way into the court system?
Well, 30 years ago, domestic violence first became a public issue. And the problem was that at that time, there was no research available. And what the court did is they used common assumptions. They assumed that domestic violence was caused by mental illness, by substance abuse, and by the behavior of the victim. Well, we now know that all of that is wrong, but the court continues to use practices that they developed at a time when they had no research. and it's working really poorly for children. That's what this book is about.
Mm-hmm.
It takes all of the up-to-date research together in one place from experts in the US and Canada, from many different disciplines, but all of the research confirms that the courts are making a very high percentage of wrong decisions in domestic violence custody cases.
I know I like the format of your book, how you first start off with the history of why this is happening to set a foundational basis, and then you went into why it's happening now, even 30 years after, and then you go into the solutions and strategies. And if you don't mind, I'd like to focus more on why it's happening now and the solutions and strategies to moving forward. There's a quote that you wrote in your book that I found extremely interesting, dealing with the discrediting of women in the court system these days. You said the women's normal reaction to their partner's abuse tends to be anger and emotion, and this is used to discredit their concerns. Can you tell us a little bit more about that?
Yes, and in fact, there's new research from the Department of Justice study led by Dr. Dan Saunders from the University of Michigan. And what they looked at is evaluations. And when mothers were angry, were emotional, which of course is normal when they've been abused by their partner, and then often re-abused by the court that they thought would help protect them and their children. So if they get emotional, if they are angry, the evaluators who don't understand that are using this against them, thinking that that's how they are as parents. And what we see over and again is that safe, protective mothers are losing custody to abusers and often totally shut out from their children's lives.
I found the interplay extremely interesting, that you compared family court to criminal court, which I think many reviewers don't understand how that actually plays a role in why this is happening. With criminal court, we're focused more on equity and justice. And in family court, in your book, you spoke about how the evidentiary issues where the mother comes in saying that she's been abused and she's considered a cooperative witness in a criminal court case, but when she's in family court, you described it as being uncooperative. And can you explain more about the interplay between family court and criminal court?
Yes, I mean, they have different purposes. Criminal court is supposed to be about holding men accountable. And we should say that the research shows that the only thing that changes men's behavior is holding them accountable or monitoring their behavior. So the criminal court, to the extent that they impose sanctions for men who were abusing women and children, that's the only thing that's been shown to work. But when we get to family court or custody court, routinely they're working on asking the parties to cooperate. They're trying to bring the father into the relationship with the children, and often not considering safety. I mean, you would think that the first priority would be the safety of the children, and the second priority would be outcomes that give children the best chance to reach their potential. But what we're seeing is just the opposite, that the courts are focusing on making sure the father's in the relationship, rather than making him behave so he can be a good father. And it's working poorly for children.
And why do you think judges are still doing that to this day and age? It's been 30 years.
Well, as I said, 30 years ago, there was no research. So courts and court personnel did not get into a habit of looking at up-to-date research to understand these cases. So we'll often see cases where you have an evaluator and they haven't any training or very little training in domestic violence. You ask them about research and they know nothing, but the court doesn't take that information and discredit what they're saying, because they've been taught that someone with a mental health degree has expertise in domestic violence, even though you can become a psychiatrist, psychologist, social worker without any training in domestic violence. And most of the court mental health professionals have at most a couple of hours and keep getting it wrong.
Can you tell us more about the children that were being sent home? I know that you have extensive research that you've done on these children that are being sent to the abusive parents.
Let me tell you about the Courageous Kids, which really talks about that. And we have a chapter in the book about Courageous Kids. These are children who grew up in the court system, were sent to live with the abusive parents. Usually they were separated from their, say, protective mother. And they describe what it was like, and it's really horrible. And then they are now in their late teens, early 20s. They've aged out of the custody order, and they're speaking out in order to help other children so that they don't go through the same things. And if you think about it, these children have a moral authority that the rest of us don't, because the court was acting supposedly in their best interests, and in reality made them suffer horrendous abuse. And if you think about it, if our custody court system was working, what you would ask is, how have the decisions worked out? And we don't have that research. The closest thing we have is the courageous kids. And what that says is that it's working terribly.
As a recent law school graduate, we spoke about family law, and the standard was in the best interest of the child. And even to me, that was kind of a vague standard that judges kind of go by to figure out which home is the best for the child. Can you explain to our viewers more about this best interest of the child standard?
Yes, it's very much a problem, because as you sort of figured out, it's very subjective.
Extremely.
Most states have a list of factors that are either by the legislature or case law about what a court is supposed to consider, and there's no order to it. They don't have a priority. And as I said before, if it made any sense, the first priority should be the safety of children. The second priority should be arrangements that give children the best chance to have a successful life, to reach their potential. And that's not what's happening. They often work in many other issues, economic, what kind of house it is, which parent will support the other parent most, and they're not focusing on what's best for children.
We spoke about the money issue earlier, which I found extremely interesting. Can you tell us more about the kind of economic issues the judges are taking into consideration?
Well, I think what we're really talking about here is that domestic violence is about control. Men who abuse women use a variety of control tactics, one of which is financial. Because often one of the mistakes the courts make is they're only looking for physical abuse and they miss all the other information. But what lawyers and mental health professionals in the court system have figured out is that abusers control the money in the family, so that if they want to make a lot of money, they need to develop practices and approaches that support abusive men. And that's what we see. And very often the courts will appoint these professionals to be evaluators, to be law guardians, guardians ad litem, thinking that they're neutral, when in fact they support abusers. And then when you want to challenge them, the court is saying, how dare you, this is a neutral who's telling me this thing.
Actually, going back to the evidence of the bruise, you mentioned the incident-specific approach.
Yes.
You said, when the incident-specific approach, do you want to explain what that is?
Yes, what happens so often in court is that there are many incidents that have occurred, and what untrained professionals do is they want to look at each incident separately, and you can't understand it that way. What domestic violence experts understand is you want to look at the pattern. You want to look at all of the different behaviors that abusers use to maintain control, to monitor his victim, and by only focusing on each incident, the court has no chance to recognize the pattern.
As you said, when the incident-specific approach is used to frame allegations of abuse in family court, the cumulative fear victims experience can appear grossly disproportionate to the evidence, lending credibility to perpetrators' insistence they're exaggerating, lying, or crazy. Can you tell us more a little bit about how judges perceive women using this incident-specific approach?
Well, and we'll talk a little bit later. One of the fundamental problems is the myth that women make false allegations of abuse frequently, when in fact it's rare. And so judges have been trained that you look at each incident separately. And by doing that, it really is hard for them to understand what's happening. And what particularly happens is you will have a trial and they will make findings and they'll find that there's no abuse. And then more events occur and maybe there's a new petition to court and the judge will, well, we already heard this evidence, so either we won't consider whether the father's abusive because we already decided he wasn't, or we're only going to look at the new incident outside of the context of the prior evidence that we had. And that's a good way to get it wrong.
Well, playing devil's advocate here, what about the women who withdraw their petitions for restraining orders, or they return to the abusers, or any of those kind of incidences that we hear so much about the news, where a woman does come to court saying that she's been abused, but then all of a sudden her actions are completely contradictory towards what that would imply?
I think you're referring to a wonderful chapter in this book written by Judge Mike Brigner. And the context is that courts are having a hard time recognizing domestic violence. And one of the reasons, and Judge Brigner talks about training other judges, and they ask him this question, what do we do about women who are lying? And when he says, well, what do you mean by that? He says exactly what you were talking about. Well, they go back to their victim. There's not a police report or a medical report, or they seek an order of protection and then they don't pursue it. Well, the fact is that that's normal behavior for women who are trying to be safe. And lots of times if they pursue their claims, they could be hurt worse. But if judges and other professionals treat this as if it proves she's lying, they're going to eliminate so many valid complaints, which is exactly what's happening. And if I can give just one more example, very often we'll see professionals observe a father and children interact with each other, and the children don't show any fear, and the professional who doesn't have the training that they need is saying, aha, these children are not afraid of their father, the allegations of abuse couldn't possibly be true. In reality, what the children understand is that their father would never hit them in front of witnesses, particularly someone the father is trying to impress. And so there's no need to be afraid then.
When these professionals that are viewing them and evaluating them, what kind of professionals are you speaking about?
I'm talking about evaluators who are often psychologists, but not always, judges, lawyers, child protective workers. Those kind of professionals do not have the training that they need. A lot of the training they get has been misinformation, and so they keep making the same mistakes because they're not looking to the up-to-date research that's needed.
And when you say misinformation, I assume you're referring back to 30 years ago when they believed that domestic violence was a mental disorder? Or what other kind of...
That's part of it. I mean, there's a tremendous problem in terms of the use of mental health professionals. They will do these psychological tests and use that to create an illusion that there's a scientific basis for what they're saying. The reality is these tests were not invented for the populations that we see in custody court. And under the best of circumstances, these tests are about 55 to 65% accurate. But under some certain circumstances that are very common in contested custody cases, such as domestic violence, such as the pressure of being in a contested custody case, the percentage is much lower. And what we'll see often is that the tests will show that the woman is defensive or fearful, and they're going to treat that as a pathology rather than a normal reaction to her partner's abuse. And so you keep getting this kind of misinformation, from the court. But I guess we should talk about this myth that women frequently make false allegations. The reality is, it's not that it never happens. If it never happened, it wouldn't be a myth. But it happens only about 1 or 2% that mothers make deliberately false allegations. But that study that I referred to by Dan Saunders showed that particularly evaluators who don't have training in domestic violence to the extent that they need are much more likely to believe that myth and in turn make recommendations that are harmful for children. Interestingly, there's a study by Nick Balla who looked at many studies of false allegation by fathers and found out that fathers in contested custody cases are 16 times more likely to make false allegations than mothers. And it's not that men are that much more dishonest than women. It's specific to contested custody cases. As we said before, 90% of contested custody cases are domestic violence cases where abusers are using the tactic of going after custody as a way to maintain control over his partner. These are men who think she had no right to leave, and therefore he's entitled to use any tactic, including false allegations, in order to get his way. And the courts are not understanding what is going on. And so they get manipulated by abusers who are very good at manipulation and are disbelieving mothers who are making true allegations.
So you speak about that, about how there's a new kind of wave of abuse that these men are using, where they're using the court system to spend excessive lawyer fees, court fees, spending time in court. Can you speak more about that?
Yes, you know, there is a group, they like to call themselves fathers' rights people. They're really male supremacist groups. And they represent a very small part of society, but they're very loud and aggressive. And a lot of courts have been led to believe that they have to treat mothers and fathers equally, and what's left out is regardless of past parenting. And so in our society, which is still sexist, where mothers still do most of the child care, so that they are the primary attachment figure, which means a lot in terms of the well-being of children, that's not considered sufficiently. The same thing with domestic violence. Fathers who come to court who have been abusive to their partner seriously harm their child. So they shouldn't be treated the same as safe mothers. But the courts have been told that children need both parents in their lives, which is true unless one of the parents is abusive. But they didn't hear that part.
And when you speak about primary attachment, what do you mean in the court system?
The parent who does most of the child care in the first 2 years of the child's life is the primary attachment figure. And the child has a very strong need to stay with the primary attachment figure. Children who lose their primary attachment figure are more likely to suffer depression, low self-esteem, and to commit suicide when they're older. So that it doesn't make sense to separate a child from their primary attachment figure unless that parent is really unsafe, by which I mean a drug addict beating the child, something like that, not because she makes a couple of negative remarks about the other parent. That isn't in the same level of importance to the child.
So you're saying that the judges don't generally consider who the primary attachment is to the child?
Right now, the courts are focusing much more on negative statements by one parent or the other, how the parents can cooperate, things like that, because they're thinking of it as a high conflict case. And they're missing what is most important to the well-being of children. And again, they haven't been trained properly. They haven't been taught what's most important for children. I mean, the importance of our book is that we place children first. We talk about what is most important for the safety and for the ability of a child to reach their potential. You would think that's what best interest of the child means, but it's not what it means in today's courts.
So when you think about solutions and strategies for the future of how to fix this problem, what do you generally think of?
One of the things is that we need a retraining of the professionals. And I say retraining because, as we've talked about already, there's a lot of misinformation that judges and other professionals have received. They have to learn that that's not true. And then they need some basic information. Instead of just learning generally about domestic violence, they need to learn how do you recognize domestic violence. They need to learn about gender bias. They need to learn about the effects of domestic violence on children. They need to learn a better way of using mental health professionals so that they're only used in areas where they have genuine expertise and they're needed. And they need to learn how to respond to child sexual abuse, because a very high percentage of valid cases of child sexual abuse are denied. And not only is the child sent to live with the sexual abuser, but usually the mother is thrown out of the child's life because they're assuming that she's making a false allegation.
When you say gender bias, I actually want to touch on that because much of this discussion has been on a male abusive father. I wanted to know what your thoughts are about the female. You spoke about a case where the women generally had higher burdens of proof. So this isn't just us throwing abusive male father. There's actually statistics that support this.
There have been over 40 states where their court systems have created gender bias commissions. And they have all found widespread gender bias. In New York, there was the Commission on Women in the Courts. And what they found is that routinely women face higher standards of proof, are given less credibility than the men, and are often blamed for the men's behavior. In one particularly egregious case in this state, the court used a certainty standard for the mother and a probability standard for the father.
And what does that mean in legal terms?
Well, in a civil case, the standard is supposed to be preponderance of the evidence, which I'm sure you learned just recently. And that's basically a 50-50, who has shown more evidence. In this case, what happened is they used the preponderance standard for the father for what he had to prove, but for the mother, they only were willing to consider evidence that she could prove to a certainty. Well, no one can prove a certainty.
Of course.
You know, the best mother in the world, could not prove that. And the interesting thing is, when this was appealed and this issue of the different standard of proof was raised, there were at least 15 or 20 different judges in the appellate division that looked at this, and not one of them said, hey, you can't do this. Now, you know, a first-year law student would know that you can't use certainty for the mother and probability for the father. It's a fundamental violation of due process and equal protection, and yet all of these judges missed this case. And it's not that, the judges could not have been bribed. It's not that they're not smart enough to know this. It's that they're in a system that is so broken, where they've seen the wrong things happen so frequently that something so clearly wrong was allowed to go by.
So you believe that we need to be retraining judges in order to fix this problem?
That's one of the things that we need. I think the legislature should specifically say that safety should be the first issue, and the well-being of children, their ability to reach their potential, should be the second most important thing. And another thing that I would like to see the courts do that also would save a lot of money and time is, at the beginning of a case, you could have a hearing just on the issue of domestic violence, which would limit the issues. You wouldn't need an attorney for the child. You wouldn't need evaluations. The only issue would be, are the allegations of abuse true? If they are, the safe parent gets custody, the abuser initially gets supervised visitation, which is what the experts recommend. And you could have cases that now take several months or years, and we could get it done in a couple of hours, and most importantly, we'd make better decisions.
Well, thanks to your book, we can probably hope for that in the future. And I hate to cut you short, but we're actually running out of time.
Thank you, Jennifer, for a great interview. We are indeed out of time. Thank you, Mr. Goldstein, for your illumination on this very serious subject. And thanks to you, our audience, for watching. I'm Bob Ward, and this is Above the Bar.